Well, as I said, happy to have a follow-up on the discussion we were having on the last session. And if not, I'm going to move on to out of the realm of science fiction into the realm of the practical intellectual property lawyer. And I'll return first to a couple of things that I discussed at the first day for you to follow, particularly from the standpoint of patent law. Again, we're really talking in virtually all cases about domestic law and implementation. So China has a patent law, Turkey has a patent law, Spain has a patent law, the European Union has a patent law, and the United States has a patent law. We all have our own patent laws, and the patent laws are different, and the courts interpret them differently. So you can take the same problem and come up with a somewhat different solution depending on what country you're in. Now, I don't want to overstate that for reasons we'll get back to, but when you have kind of a very technical, sophisticated issue, you're more likely to see differences than in the basics. And if we look at the international agreements, if we look at the Paris Convention for the Protection of Industrial Property, and if we look at the WTO TRIPS agreement, we'll see that there are a few basic principles which underlie the entire systems. And for those of you who are familiar with international trade law, the first is a very basic principle of international trade, and this is the idea of national treatment, which you are probably all familiar with. And the idea is for a patent system in a country, you treat a foreign national patent applicant the same way you treat a local national patent applicant. You do not discriminate against the patent applicant based on their country of nationality. So it's very straightforward. The United States treats Chinese patent applicants the same way it treats American patent applicants. The European Patent Office treats a Chinese patent applicant the same way it treats a European Union national patent applicant. For most things. Now, there are some little areas where you can have differences and kind of special qualifications you need, and some documentation that may vary depending on where it is situated. But by and large, that's the main rule. And the third one, the next one is this idea of independence. And we're going to come back to this idea of independence when we look at FRAN licensing at the end of these discussions. And this is this is a rule of the Paris Convention for the Protection of Industrial Property, Article 4 bis. And the principle of independence tells you that a patent filed in any one country is different than the same patent filed in another country for the same invention. They are each treated independently by the patent offices and the courts, so that a decision in one patent office does not affect the decisions of another patent office. And so, for example, if a patent is determined to be invalid in one country, that does not invalidate the patent in another country. So if I have a patent in China and a patent in the United States on the same invention, and a Chinese court says your patent is not valid in China, that does not affect your patent in the United States. They are independent of each other. Why do we have that system? Because basically, countries have never trusted each other. And this goes for the European Union, even internally or any place, that they can rely on one country not to behave strategically with respect to patents, right? If you get a patent in China, do you want to have a United States court decide whether your patent is invalid in China? The answer to that is generally no, right? You want the Chinese courts to decide whether the patent is valid, and if an American court says the patent is valid in the United States, then it's valid in the United States, but it doesn't invalidate your patent everywhere. So this is a key part of the international system. A corollary, sometimes it's referred to in the same breath, I will say, but there are different concepts. Generally speaking, patents are territorial, meaning that your patent granted in one country only gives the patent owner rights within that country and not outside the country. So if I'm an American patent owner of an American patent and someone is doing something in China or someone is doing something in Germany that I don't think they should be doing, I can't use my American patent to challenge their behavior in China or to challenge their behavior in Germany. I have to have a German patent or a Chinese patent to enforce. And so they're independent, but they're also territorial, right? They only apply within the country where they are granted. There are some very narrow exceptions to that. For example, we have some cases where you've had, for example, a radar system or a cellular telephone system where the patent is carried out in more than one jurisdiction at the same time. So in order to get a radar reading, you need to triangulate your system between one country and another country and maybe a ship out at sea. So the signal is going to different places. Some are not within the country where the patent is granted, and then the patent office will look at where the central focus, where the central operation of the patent is. So you do have some narrow exceptions to this idea of territoriality. The third, and again, these are all very important, these are the bedrock principles. The third, which we discussed on the first day, is this idea of a right of priority. This started with the Paris system back in 1883, and the idea is that when I file my patent application in the first country, I then have a period of 12 months to file my patent application in every other country in the Paris system. And what happens during that 12-month period does not count. It's ignored for the purposes of priority and for purposes of whether there's any new prior art or disclosures that might prevent the patenting. If it happens after the first patent application is filed, it doesn't count. So filing the first application protects you during that 12-month period where you file your patent application everywhere else, and you don't have to worry that someone's going to make a disclosure in that intervening period. Now, when we look at the rules, so first I mentioned to you on the first day that the Paris Convention, which is the World Intellectual Property Office Convention, was a very curious international agreement about patents. It didn't tell you what a patent is. It didn't say anything about the criteria of patentability. It didn't tell you why a patent would be granted. It didn't tell you what the subject matter of a patent would be. It didn't tell you the duration of a patent. It basically set up these principles: national treatment, independence, and priority. And it left to each country then to make its own rules. And then in the mid-1980s, Europe, the United States, and Japan started to say, well, that's not adequate, right? Countries aren't granting patents. This is a problem for trade. This is a problem for industry. We need to fill in the blanks. We need to say what the criteria of patentability is, what the patent matter, subject matter is, what the duration of a patent is, whether or not compulsory licenses should be issued. We need to fill in the rules around what is a patent, right? And we need to create a mechanism for dispute settlement, and that mechanism for dispute settlement was the World Trade Organization dispute settlement body, right? So we created a place where you would resolve questions about whether a country was complying with the TRIPS agreement standards. And another important point, of course, is the TRIPS agreement linked to the Paris Convention. The TRIPS agreement wasn't ignoring the Paris Convention. So importantly, if we take independence and priority, those aren't in the TRIPS agreement. Those are in the Paris Convention, but the TRIPS agreement creates a link to the Paris Convention and says that the principles of the Paris Convention apply through the TRIPS agreement in the WTO as if they're a part of the TRIPS agreement, so they interconnect. Now, what is important about, one of the things that's important about this is while the TRIPS agreement does tell you what the basic rules are, right? That you have to apply the principles of novelty or newness, inventive step or non-obviousness, utility, and sufficiency of disclosure. It tells you you have to apply those. It doesn't tell you what those are. Right? It still remains for each country to determine how it assesses an inventive step or whether or not something is useful. So the TRIPS agreement is drafted at a fairly high level of generality, right? Leaving countries with flexibility in terms of how they implement the individual rules. Now, of course, there has been a lot of controversy about that, right? Since the beginning, since 1995 and moving forward, you've had arguments about whether or not countries are properly applying those rules or not, but I'm not going to go into those questions because that's a whole history of WTO dispute settlement. But I did mention that, of course, there are things that drive us towards uniformity. And one of those things, which we're going to look at in a minute a little bit more closely, is something called the Patent Cooperation Treaty. So if you look at Chinese patent filings, you'll see that most of the filings are done through something called the PCT system. The Patent Cooperation Treaty system, and if you look, for example, if you go back and look at that DeepMind patent that I showed you, that we looked at on the first day, you'll see that that's a PCT filing, right? And it shows you, and we'll look in a minute to give you a better idea, it shows you where the various countries where Google was designated as the place where those patent filings would eventually be made. And because the PCT has a common form of application, right, what needs to be in a patent application, and because it provides for an international search and an international review of the patent application, which isn't binding, and we'll get back to that, but an international review, it drives patent applicants to a certain uniformity in their filing. So that even if the TRIPS agreement doesn't say you need to do specifically this, this, and this, if you're applying to the PCT system, you have to say these various things, so it creates a certain uniformity in how patents are approached. The other thing that creates a certain uniformity is today you have a number of patent offices that cooperate with each other through a mechanism called patent prosecution highways. There's different patent prosecution highways, but there's systems in which the patent offices agree to accept determinations or assessments made by each other so that they can accelerate the process of review. So you may file a patent application in the European Union, where the European Union will have relied on a search and examination report prepared by the U.S. Patent Office as a way to making the process quicker, and this is a work in progress, but you have any number of these PPH, patent prosecution highway agreements that facilitate the filing of patents. Now, I'm going to divert for a second here, digitally divert, I should say. So, I told you about finding things, right? So if you're an intellectual property lawyer or an intellectual property researcher, there's a tremendous amount of information on the World Intellectual Property Organization website. You can find all the agreements, you can find the detailed information about how to file a PCT application electronically, and the filing fees, and how you designate the various countries and so forth. But the question we'll just discuss briefly here is, how does this work, right? So what happens with generally speaking, filing a patent application? So the inventor who we discussed has an idea. Once the idea becomes sufficiently concrete, then they may be ready to file a patent applicant. We actually call that process of making it concrete reduction to practice. So we use the patent lawyer terminology, right? When you take the idea and you turn it into something that you can make work, we call that reducing the concept into practice, reduction to practice. And just as a general matter, filing a patent application is referred to as constructive reduction to practice. When you file your patent application, you are assumed to have put it in a state where you actually have the invention and can describe it. And once you've got your idea and you've reduced it to practical application, you file it with the patent office. You file it with the first patent office. Now, and when you file it with the first patent office, you get both a filing date, which is the date you file the first application, but that first filing is also called the priority date, right? That is both your initial filing date and your priority date when you first file. Now, this is a bit of a technical detail which I mentioned. In principle, you could file your first application directly with the World Intellectual Property Organization, but as a practical matter, you really can't do that because almost all countries have a national security review process. So when you file a patent in the United States, there is a period of about 60 days for the patent office to review your application and make sure it doesn't raise national security issues. and you're not allowed to file it outside the United States until the patent has gone through a national security review. So this is common. Virtually every country has some type of national security review after the patent is initially filed to make sure that they're willing to let you make the information public. It usually has to do with the military. If you're filing a patent application that has clear military potential, that your Defense Department might say, no, we don't want you to send that convention abroad, we want to make that secret here. It doesn't happen that often. It is a thing. Then, from the initial filing date, you have a period of 12 months. You have 12 months until you then need to file your PCT application, right? So that's the cutoff date. I have 12 months to file my PCT application, and then when you file that PCT application, you tell the PCT office, you designate countries where you may eventually want to file your patent application. Usually if you're a big company, again, it's a technical detail, there's a box in the PCT application, you can just say designate all, right? That's the most common, because you're reserving your options, right? I'll decide later where exactly I want my patent application filed. That later determination actually has to do with the amount of money you pay, because you have to pay additional money when you file in the individual jurisdictions later on. So you designate the countries, and then you designate something called an International Search Authority, or an ISA. There's many ISAs. China can do an ISA, Europe does an ISA, the United States is an ISA. You designate one patent office that's acknowledged by the World Intellectual Property Organization to carry out a prior art search, right? And to give you a report of what prior art looks like it might, then patent lawyer terms, read on or cover material in your patent application. And by the end of 16 months, you'll see here, let's not get too complicated here. The end of 16 months, that International Search Authority gives you your search report. And you might get that search report and it might say, there's lots of prior art on this invention, and as the patent applicant, you may say, well, maybe I shouldn't file for a patent because I'm going to dispose my invention and I may not get a patent, so I'll just withdraw my application. So if you can withdraw your application up until 18 months, but at 18 months, your application and your international search report are published, right? So that's kind of the all or nothing thing, right? At 18 months, you have to decide you're willing for the world to see what you filed in your patent application, and so therefore that wouldn't be a trade secret anymore once that publication occurred. Now, in principle, you can go from that publication to filing in a designated office, but you don't need to, and very few people do. Instead, you can request something called an International Preliminary Examination Report, which again can go to any number of international preliminary examination authorities. They're called IPEAs. And then as the patent applicant, you're going through the same process with an IPEA that you would ordinarily go through with your domestic patent office. They are telling you, well, we don't like the way your patent is drafted, your claim is drafted. We think maybe you should draft your claim another way to avoid prior art. So you can have a dialogue with the International Preliminary Examination Authority, And then at the end of 28 months, the IPEA issues its International Preliminary Examination Report, and then you have the option as the patent owner within 30 months, so now you've got up to 30 months from the initial filing, to have that application transmitted to any or all of the countries that you have designated in your patent application, in your PCT application. And when you transmit to that National Patent Office, then it essentially becomes a national patent file, right? Then it is up to the National Patent Office in the places you have designated to decide whether or not you're going to get the patent. It is not the Preliminary Examination Authority that decides whether you're going to get the patent. It goes to the National Office, and that's important because that's when the differences in national patent law come in, right? The National Patent Office says, well, we understand the report from the IPAA, but we have some additional things we look at. So we want to look at it more deeply, and we may want other changes. We don't need to automatically grant you the patent. Now, and that could take, again, a period of time before you actually get the patent from that designated office. The critical thing, and the reason, there's two reasons, at least two reasons why Chinese companies and other companies, US companies, every big company uses this PCT system. It's because of this extended priority period that you reserve your rights not for 12 months, but for 30 months. And you do not really need to make a decision about whether you're going to file that application in the national offices until 30 months are up. And anything that has happened during those 30 months doesn't count. So if someone made the same invention in month 28, that would not take priority over your application. The date, your right to get a patent traces back to the very first day you filed your patent application here, and rather than under the Paris Convention expiring after 12 months, that expires after 30 months, right? When the application is transmitted. So what companies will tell you, so this process can be very expensive, right? Because when you then go to the national offices, you often have to provide translations, you have to appoint local agents, you have to pay fees. There's all kinds of things which go into ultimately filing your patent application. So by the end of 30 months, companies will tell you, well, by the end of 30 months, we know whether something is valuable to us or not, or at least we have a good idea. We may not have a good idea after 12 months, but by the end of 30 months, we have a very good idea whether this is valuable technology and whether we want to proceed, because it may cost $50,000, it may cost $100,000 to file these patent applications in many countries. So you don't necessarily just want to throw that money away, even if you're a big multinational company. You may have lots of patents, and you want to be more selective about where you're filing. Now, the objective of this course here, and you can find different, if you look at this site that I've shown you with just the PCT frequently asked questions, which is now where they have these diagrams and so forth, and answer various questions. The reason, first, some of you might be going into this area and be interested in this area, so I want you to be familiar with this. The second is when I talk about the fact that, we don't really have a global patent Well, let's start with that one very basic fact, which I haven't really said yet, so I'll say it. There is no such thing as a global patent. That I went someplace, I filed a patent, and someone gave me a patent that stood over all over the world. That doesn't exist, right? The thing that comes closest to having a global patent is a patent filing through the PCT system, which is then extended to as many countries as you want to extend it to, and basically every significant economy is part of this PCT system. So basically, anywhere you want to apply, you can do through a PCT application. But that's the closest we have to an international system. But going back to an earlier point, this creates a certain uniformity, right? A company can't say, well, I'm going to file my application in Belarus because I know that the patent office in Belarus is more likely to grant me a patent. Well, that might be true. You might get a patent from the Belarus patent office, but that doesn't mean you're going to get a patent from anybody else, right? So you need to be a bit careful about where you're thinking about getting the information you're putting in a patent application, because you're going to be filing that patent application in many different patent offices. You have to keep the information the same by and large. So what this means is there's a driving tendency in the system for patent systems to approximate each other, because you can't afford to just simply say the wildest thing you can think of and get a patent office in one country, because it's not going to make any difference to all of these other places where you want to do business. So you have to approach it from the standpoint, systematically, how am I going to get my patent around the world? And I thought it would be useful to you to have kind of a basic introduction about how all of that works, even if, you know, we haven't gone into any great details about that. So I think to a certain extent this is what I've just covered. So business enterprises typically seek to patent their inventions in all or most all commercially relevant markets. So you have a certain uniformity introduced into the system, because if you're filing a priority patent application and you want to have it applied for in all the other places, you can't keep changing the information on your patent application because you'll lose your priority. And I hope that explains it, right? You have to approach it from a system-wide approach. The European Union Patent Office is pursuing one specific thing, which is called a confirmation patent, and this is relevant for some developing countries. This is the idea that your patent office in your country will rely on the European Patent Office decision about whether or not to grant a patent, and will simply confirm that patent in the foreign jurisdiction. So that's called a confirmation patent. Technically, it's a separate patent, but you're just taking the European Union patent, saying we agree they did everything correctly. We're just going to confirm and grant that patent in our system. So the European Union is pushing that. But that would obviously also have a tendency to create uniformity, because you'd be using the same patent and the same patent application. My goodness, it's 10:20, I can hardly believe it.